They built their dream house 6 inches onto my land. 6 inches. And by the time the dust settled, that little slice of red Tennessee clay cost them more than 100 grand. Which sounds petty until you realize this wasn't about dirt. It was about being told to smile while somebody poured concrete over a line you warned them not to cross. My name's Daniel Harper, and I own a long, narrow 5-acre strip outside a little place called Mill Creek Hollow, about an hour from Nashville. The kind of land that doesn't make postcards, doesn't trend online, doesn't impress anybody who shops for houses by granite countertops and open concept floor plans. It's oak trees, cedar brush, red clay, a gravel drive that pops under your tires, a modest cabin I fixed up over the years, and a workshop out back where I lose entire Saturdays rebuilding old engines for no good reason, except that I like bringing stubborn things back to life. My dad bought the place in 1987 for 48 grand and thought he got robbed. Back then, this road was scrub woods, cattle fences, and a gas station that shut down at sunset. When he passed, the land came to me clean title, recorded survey iron stakes, driven deep by somebody who knew what he was doing. Out here, those stakes are more than metal. They're trust. For years, the lot next to mine sat empty, 5 acres of weeds, trees, deer tracks, and silence. I liked it that way. Quiet can become part of your nervous system if you live with it long enough. Then one day, the city rolled in wearing new boots and a glossy smile. Evan and Claire Reynolds bought the parcel next door, early 30s, remote tech money, black SUV so clean it looked offended by gravel. They introduced themselves like they were auditioning for Friendly Neighbors of the Year. Evan had that polished, practiced confidence. Claire had one of those wide-brim hats and a soft voice that somehow still felt curated. "We're building our forever home," he told me. Claire smiled and said, "Fresh air, slow living, reconnecting with nature." I nodded because I don't have a problem with dreams. I just know dreams can get real expensive when they stop listening to reality. Within a month, the trees started dropping. Heavy equipment rolled in concrete trucks, framing crews, backup alarms beeping from sunrise to supper. They hired an architect out of Atlanta and a contractor named Marty who drove a lifted truck with his company logo slapped on both doors like a political campaign. Every day there was noise, men yelling measurements, diesel fumes, and the sound of progress. Every night, apparently, Claire posted about it online. I only found out because my sister called me laughing and said, "Danny, your neighbors are influencers." Sure enough, Claire had some growing Instagram account documenting their rural reset. She'd stand out there in front of the cleared lot holding a coffee mug, talking about intentional design stewardship, honoring the land. Stewardship, that was the word she kept using. And I remember thinking, funny word for somebody who hasn't even learned where her property line is. One afternoon, I was walking my boundary like I always do every couple weeks, habit from my dad, I guess, and I noticed the concrete forms for their foundation looked close. Not, that seems near close. Gut tightening close. I walked straight to the iron survey stake at the line. It was right where it had always been, rusted, half-hidden, solid as truth. Then I looked back at the corner of their footing. Over, not by feet, not by some dramatic chunk of land, by about 6 inches. Now, 6 inches doesn't sound like much until it's yours. You can laugh off 6 inches in a haircut, a fishing story, a bad tape measure, but land doesn't care about vibes. Land is lines. I stood there staring at that gray concrete edge like it had leaned across a dinner table and called my father a liar. I walked over to Evan, who was standing near a portable toilet looking at plans. I kept my voice calm. "Hey, got a minute?" He smiled. "Sure thing, Daniel. What's up?" I pointed toward the corner. "Your foundation crossed the property line, about 6 inches onto my side." He blinked, then pulled out his phone like I'd accused the moon of trespassing. He opened one of those property apps, zoomed in on a satellite image with colorful lines floating over it. "See, we're good. Lines are right there." I looked at his screen, then at him. "Those apps can be off by 10-15 feet. They're not survey grade." He gave this little chuckle. "Those old stakes shift all the time. Frost, rain, whatever. We had everything from county records. Did you get a licensed survey done?" A pause. We had the lot lines. "That's not the same thing." He sighed like I was dragging down the mood at a barbecue. "Look, we already poured. Even if it's a few inches, it's not hurting anything." That line, "not hurting anything," hit me harder than I expected. Not anger, not yet. More like a bell going off in the back of my head. "It's my land," I said. 6 inches or 6 feet? He gave me a tight little smile. Let me talk to the contractor. I'm sure it's fine. Construction didn't stop. Of course it didn't. Forms came off framing, went up, and that 6 inches of concrete turned from mistake to monument. So I went to the county, got copies of both recorded surveys, and walked back over there with the papers under my arm, still hoping this would be one of those simple adult moments. Look at the facts, fix the problem, move on. Evan was up on the frame subfloor talking to Marty. Claire was filming near the driveway, narrating something about reclaimed wood and natural light. I called Evan over and handed him the surveys. These are recorded, the stake hasn't moved. Your footing crossed the line. He barely looked at them before handing them back. We're way too far into this to start second-guessing everything. It's not second-guessing, it's a boundary. He exhaled slow, then changed tone. Not friendly anymore, more business. Okay, let's be practical. What do you want? I want you to fix it. Tear out that section and re-pour inside your line. Marty let out a little laugh under his breath, one of those contractor laughs that says, "Bless your heart, old man." Evan shook his head. That would cost a fortune. We're already framing. That's not my problem. Then he hit me with what he thought was the grown-up solution. What if we just adjust the line boundary amendment? I'll pay all the fees and give you, I don't know, $1,000 for the trouble. $1,000? For land my father bought before this guy probably learned long division. It's not for sale, I told him. It's 6 inches, he snapped, patience finally cracking. You'd never even notice it. I noticed it. Claire had wandered over by then, phone lowered but still in hand. We're not trying to take anything from you, she said, all soft voice and hurt eyes. We just want to build our home. We thought everything was right. You thought I said, but you didn't verify. That did it. Evan stepped closer, voice low. So you're really going to make us tear down part of our house over this? I'm asking you to fix what you built on my property. You're being unreasonable. That word hung there like thunder in August. Unreasonable. Funny how fast "hey neighbor" turns into "you're the problem" when somebody wants what's yours and doesn't want to pay the real cost. I left before I said something stupid. That night I lay awake, staring at my ceiling, replaying the whole thing. I asked myself the same question people still ask me now. Should I have let it go? I wasn't planning to build on that exact strip. 6 inches wasn't going to change my life. But here's what I've learned, and I learned it long before this mess. If you let people cross your line because it's small, they don't remember your kindness. They remember your line moved. A week later, walls were going up windows, delivered, no surveyor in sight, no correction made. So I called a lawyer. Margaret Collins, late 50s, sharp as broken glass, no wasted words. Her office smelled like old books and coffee and the quiet confidence of somebody who has seen every trick before it's played. I told her the whole story, the stake, the app, the offer, the refusal. She listened, leaned back, and asked, "Did you give written notice?" "Not yet." "Good, we'll do it right." She sent a formal notice demanding they cease construction and remedy the encroachment. Clean, factual, no drama. Construction continued. Then came the letter from their attorney-polished Nashville guy, Thomas Avery, arguing the encroachment was minimal cause, no material harm, and that forcing demolition would be unconscionable. Margaret read that word out loud and gave this tiny smile. They poured first and hoped law would become negotiation. That's not equity. That's negligence. Their next offer was $5,000 for a permanent easement. For folks who don't speak land law, that means I'd grant legal permission for that corner of their house to sit on my property forever. $5,000 and a smile and everybody goes home. Margaret looked at me and said, "If you sign, you never get it back." I stared at her ceiling for a while, listening to the air conditioner click and hum. Then I said, "File it." So we sued. And while motions got filed and surveyors got scheduled and I started bleeding money by the hour in legal fees, they kept building the dream. Siding went up, landscaping went in, wraparound porch, cedar posts, string lights, the whole country piece package. Claire posted a house tour video with some title like "From City Chaos to Country Calm," talking about community and gratitude, while I walked past that corner every day feeling like it leaned over the line just to prove a point. People online called them brave, inspiring, intentional. Meanwhile, I was paying to defend a boundary they'd already admitted was only 6 inches. About 4 months in, Evan came over looking worn down, no smile this time. "This is getting out of hand," he said. "You could have stopped it before the concrete cured." He dragged a hand through his hair. "We've got almost $800,000 in this house. Our lender's nervous. This lawsuit is scaring people." "I warned you. It's 6 inches, Daniel. And it's my 6 inches." He stared at me like he still couldn't decide if I was stubborn or crazy. "What do you actually want?" I said, "I want you to understand you don't get to build first and negotiate later. He shook his head. You're going to burn goodwill in this town. That almost made me laugh. Goodwill, in my experience, is what people call it when they want you to eat the cost quietly. The case dragged on 8 months. Depositions, maps, expert reports, all of it. Then came the twist, not to me because I knew, but to everybody who thought this was some cranky neighbor tantrum. The license survey came back and confirmed exactly what I'd said from day one, 6 inches over, clear as daylight. No shifted stake, no mapping glitch, no misunderstanding. They had notice early and they chose to keep going. That choice became the whole case. By the time we got to court, this thing had stopped being about a strip of dirt. It was about whether consequences still apply when you've got enough money to assume they won't. Hearing day was gray and cold. Evan in a suit that looked borrowed from a thinner version of himself. Claire, pale and exhausted. Me, weirdly calm. Because once you've lived with a fight that long, the fear burns off. And all you've got left is the truth. Judge Holbrook was older, silver hair, wire-rimmed glasses, quiet voice. The kind of man who doesn't need to perform authority because he has it. He'd clearly read everything. Margaret laid out the timeline: notice, continued construction survey, confirmation, disregard. Avery argued hardship, fairness, disproportionate harm, community impact. He talked about the financial devastation of tearing out a structural corner and kept repeating minor encroachment like the adjective changed the noun. Then Judge Holbrook looked straight at Evan and asked Mr. Reynolds, when were you first informed of the boundary concern? Evan swallowed. Before the slab was fully cured. And you continued construction? Yes, sir. Why? Evan hesitated, and for 1 second, just one, I almost felt sorry for him. We believed it was minor and could be resolved later. The judge nodded slowly. Resolved later by whom? Nobody had an answer for that because everybody in that room knew what he meant. Resolved later by the neighbor you planned to pressure. Resolved later by sunk costs. Resolved later by the fact that once a dream house is framed, the person defending a line starts looking like the villain. A week later, Margaret called while I was at my kitchen table. You're going to want to hear this, she said. The ruling found their encroachment was willful negligence. Not accident, not confusion, willful negligence, because they were warned and proceeded anyway. The judge gave them options: pay $75,000 in damages for a permanent easement plus all my legal fees, or enter a mandatory annual easement agreement at $20,500 a year, adjusted for inflation in perpetuity. My legal fees were just over $18,000. I sat there staring out the window at the tree line, hand on the table, and the first thing I felt wasn't triumph. It was exhaustion. Deep, bone-level tired. Margaret asked how I was feeling, and I told her the truth. Tired. Not victorious, not gleeful, just tired. They tried to appeal the amount, called it punitive, argued market value, all of it. Judge Holbrook didn't move. In his response, he wrote something that stuck with me. They assumed the risk when they proceeded after notice, and the consequences were the natural result of that choice. Natural result, that's the phrase. Not revenge, not karma theater, cause and effect. A few weeks later, Evan came to my door alone, no contractor, no attorney, no performance. He looked older. We're taking the lump sum, he said, 75 plus fees. I nodded. He gave this little humorless laugh and said, Claire says you ruined the story. The Instagram story. He didn't answer, which was answer enough. After a minute, he asked real quiet, do you hate us? That caught me off guard. I said, no, I don't, but I won't be ignored on my own land. He nodded and walked back down my gravel drive. They wired the money within 30 days, $75,000 in damages, a little over $18,000 in legal fees plus survey costs, paperwork, recording fees. By the end, it was just over $103,000. All because of 6 inches they could have fixed when the concrete was still wet. And here's the part people don't expect: I didn't feel richer. The land didn't look different. That corner of their house still sits where it sits, only now it sits there legally with recorded easement paperwork stamped by the county forever. Claire posts less now, and when she does, the captions sound less like poetry and more like press releases. We nod if we pass on the road. That's about the size of it. Sometimes I walk out to that old iron stake and set my boot against it just to feel it's still there. Same place, same line, same truth. And I think about how this whole mess taught me something I wish wasn't true, but usually is: a lot of people call you difficult the moment your boundary costs them something. Not when they cross it, when you enforce it. So here's what I'll leave you with, because this part still sparks arguments all over town. If someone builds on your land after you warn them and then tells you it's too expensive to fix, whose responsibility is that? The person who crossed the line or the person who refuses to erase it for free? I still go back and forth on whether I could have done anything differently without giving up the principle. Maybe you think I defended what was mine. Maybe you think pride turned 6 inches into a war. Either way, I'd genuinely like to hear your take. Where's the line between justice and stubbornness when law, money, and good intentions collide? Drop your thoughts in the comments, and if you've ever dealt with boundary disputes, HOA nonsense, or somebody trying to pressure you into compromise after they caused the problem, tell your story too. I read more of them than you'd think. And around here, lines in the dirt still mean something.